So you just first reached your first 100 days about 6 days ago as Louisiana Attorney General. What's your first assessment of your first 100 days as AG?
You know, it's been a whirlwind. We've had 3 back-to-back sessions. It's kind of hard to grade yourself when we've been so busy. But I have tried to keep my promise to the people when I ran for office that I would fight for free speech and I would fight for jobs and I would fight crime. And I think that we have got off to a good start on all of those grounds. So, we still have a lot of work to do. I think, it's still early.
Gotcha. So looking back at the crime special session for a quick second, one of the major bills that was just passed or that was just put into law this week was the one about 17-year-olds being tried as adults. Why was that such an important push for this past special session?
We have seen the consequences of the change in the law that lowered the age, and it has had some dramatic consequences, I think, with juvenile crime across the state. So that was a very important change that was supported by all the district attorneys and the sheriffs and me, and I think that it is an important tool that we have now to be able to kind of right the ship when it comes to crime in this state. We have a lot of juveniles committing crimes. Some of those are older kids, and really they're young adults, and they're doing very adult crimes. So the consequences really need to be more severe than having them adjudicated in the juvenile system.
Gotcha. So in Louisiana, there are laws that deal with open meetings and transparency within the government as well as municipalities. Why is open meetings and public transparency in municipalities specifically important for Louisiana residents and for people that live in that said municipality?
Well, our Constitution embraces the idea that the people should have access to government operations. I think that the debate that you've been hearing in the Capitol is over where to draw the line so that government officials and people in government can do their jobs and make decisions and also provide for the transparency that is necessary and appropriate and protected in our state constitution.
Gotcha. So, and there's a bill in this session that deals with that transparency and open meetings in the state. Why is this such an important topic for not only for the media side of things, but for regular everyday citizens in Louisiana?
Look, it's always important for the people to have access to the operations of government, and our Constitution protects that. I think that the press has frequently been the most interested in public records laws because the press is covering the operations of government. But it's not just the press that accesses government documents and makes public records requests. Open meetings laws are a different form of openness and transparency in government, and we in the Attorney General's office actually enforce the open meetings laws, and we teach government agencies the rules about public records laws. I think that the bills that are going through now are generating good conversations about what should be memorialized in statute, and I think some of the conversations that you've seen about something called the deliberative process in one of the bills, it reflects something that's already in the jurisprudence, and I'm not sure that's been really fairly reflected at the table in the legislature, but it's something that I've dealt with for years.
Gotcha. So let's kind of go into that too. So Senate Bill 492, that's the public records law that's kind of getting a lot of controversy now, that says that any records reflecting advisory opinions, recommendations, and deliberations, like you had mentioned, that compromise part of a process that results in governmental decisions and different policies. So what are the pros and cons of this bill if it were to get passed through the legislature, if Governor Landry does sign it? What are the pros and cons of that?
So that is a definition that's already memorialized in jurisprudence. So we already apply that. They're just trying to put it into a statute. So I think that's what really people need to understand, is that definition in the bill is the same definition that is used by courts. So what it reflects is simply the decision-making process at high-level decision-making and policy discussions with officials who have to actually make a decision about something, and then after the decision is made, those records are public. So the decision and the implementation of the decision are public record What the deliberative process protects is that point in time when public officials like the governor or an agency head need to be able to engage in conversations with their employees so that they can have frank conversations about the upside and the downside of any decision that they have to make, and not fear that there are people looking over their shoulder and listening to what they're saying, which will change the nature of their conversation. They aren't the decision makers. It's the decision maker who needs to hear their thoughts and their ideas and be able to have frank conversations with them so they can make the right decision. And so I think what we're trying to promote when you protect the deliberative process is open, frank decision making. And then the decisions and the implementation of those decisions are public record.
So this one mainly just kind of opens up a little bit more dialogue into that sense?
I think that the bill opens up more dialogue about something that's already in the law. It's been memorialized in Louisiana case law and in federal case law. And so I think the principle behind it is simply to foster frank, open conversations among decision makers and their policy and their staff, so that they can help make better decisions. And it recognizes that there is a separation of powers element there too that needs to be protected, so that the executive branch, which is in charge of enforcing the law and executing the laws, can do that without the interference of other branches of government. And that's the principles basically behind the deliberative process.
Gotcha. So going into LNG exports, right? There's a huge lawsuit against the Biden administration over liquefied natural gas. You and 15 other states are filing suit against the Biden administration for this. How does Louisiana rely on LNG exports, and how can Louisiana improve its economy if this lawsuit not only goes the way that you want it to, but for an economy standpoint for Louisiana?
So I'm leading that lawsuit because Louisiana has so much invested in the infrastructure surrounding the liquefied natural gas, export of liquefied natural gas. We do export it to countries that do have free trade agreements with our country, but we also export to countries that don't have free trade agreements with our country, like Europe. So all of Europe is within the group of countries that do not have a free trade agreement, and that's what was stopped. So I think that it affects investments in that infrastructure. So these are long-term, very, very expensive investments that are required to support an LNG export facility, and the need for that energy is not going away. And so those countries who we would be otherwise supplying are going to get their energy needs met somewhere else. And their choices are very small. Their choices include Russia, Qatar, Middle East, China. So, we saw some of this in during the Ukraine war with Germany, when they were not able to supply their needs. So I see this as a huge threat, not only to Louisiana's economy, but to domestic infrastructure surrounding energy policy here in the United States. Because if they can just stop issuing permits on liquefied natural gas when the law tells them to issue them, then they can do that with those that supply internally too. And so, I think that it's a problem with the Biden administration making decisions that are not supported by the law, exercising authority that they do not have in the law, and then just daring someone to come and stop them. So we filed a lawsuit, me and my colleagues and I filed a lawsuit to do that because they have no legal grounds for doing it. But let's be clear, this is an existential threat to democracy, not just here, but in other countries, because when you don't have stable access to power, you're going to have significant problems. It's destabilizing worldwide.
So really, if this stops here in Louisiana, that'll create a more chilling effect for other places around and other places that won't be able to have access to LNG.
Well, it makes them dependent on other sources to obtain it. And those sources are not, they don't have the same strict regulatory environment that we have in the United States. They then move toward other means, potentially, of supplying their energy needs. We have seen that when we restrict energy access here, that people will obtain it from the countries that can supply it.
Gotcha. So shifting gears to House Bill 800, this is the Constitutional Convention bill. It would start at the end of May, and it would have all of the legislators as well as 27 delegates picked by Governor Landry. There's a lot of pushback on the convention as to if it's going too quick or if this is happening way too fast. How pressing is this convention for Louisiana, and do you think this needs to happen as quick as it's happening?
Well, I do think it needs to happen. I mean, I will start there. I think that there is pretty broad agreement that we need to have a constitutional convention. I don't think there's been as much conversation about what we need to do in the convention. And so I think that's what's generating a lot of angst, if you will, about the timing of it. So if we really, I think if everybody in the public understood that the objective right now is not to rewrite the entire Constitution. And we asked for an amendment that was put on the bill today when that bill was being debated so that I can be an advisor to the convention if in fact it happens. But I think that the objective, as I appreciate it right now, is to just kind of skinny up the convention, skinny up the Constitution, to remove some things that really shouldn't be in a state constitution, put them back into statute, even if they would have a higher vote threshold to, for example, if there was a dedicated fund that's now in the Constitution, if you moved it into statute, you can still have a higher vote threshold to access those funds. You know, we have historically had a constitutional convention. I think the 1921 and the 1973 constitutional conventions were both driven by a need to shrink the Constitution, not expand it. So I think that's what the objective is. You really don't need a lot of time to do that. I don't think every single thing. Our Bill of Rights, for example, in our Constitution, I don't think that's up for grabs.
Right.
Yeah.
And Governor Landry has definitely spoken a lot about it too, especially at the beginning of session, right? He mentioned like Constitution 72,000 words. It's one of the more longer ones in the country. And yesterday when he gave his remarks at Central Louisiana Day, he mentioned about, you know, different articles that need to be changed in that. Is that part of that process, just trying to trim it down and not changing the entire Constitution like you mentioned?
Right. So I think that if there is a broad enough agreement, and if they can agree on how the votes will work, which is really where the discussions are taking place right now, what the vote thresholds will be, how they will divide it up. I think those decisions have to be made, or I'm not sure that it makes it through the process. They have to agree on that before we can ever get to the next step. But if what we're talking about is looking for some consensus on what should be taken out of the Constitution, that's a far different and much more narrower conversation than having to decide how to rewrite sections that are already in the Constitution, and to do that for multiple provisions. I think that's a harder task, and it takes a lot longer.
So you had mentioned not necessarily about like the timing of it, but just making sure it's like more narrow and more sufficient with that. What do you believe would be a too quick turnaround for that? Would it be like a couple months into that, maybe like a year? Like what all would go into how long this convention could be?
I don't know. I don't think I can really answer that question. It's too hard to predict it. It really depends on whether they do have a broad consensus about what should come out. If that's really the focus of the convention, then I think that they start there by looking, and I believe that there already is some general agreement that there are certain areas of the Constitution that deal with public finance and just these are dedicated funds. These are methods of dealing with budget deficits. These are all things that are very detailed and written in the state constitution. They don't necessarily need to be there. But I think that if they look at what you can do to trim it down and what you can move out, that is a different conversation than how to rewrite all of those provisions. So it's just impossible to say how long is too long or how short is too short,
right?
Unless you really know exactly if they have a very strategic and focused objective, then I think you don't need a lot of time to do that. If you are going to go back in and rewrite everything, then it's going to take a long time because people are going to be disputing what every comma means,
right? Yeah,
what every word
that.
means.
Yeah,
it's and we do this in the legislature. That's part of the process. The Law Institute does that on a regular basis, where they go back and they look at statutes and they try to draft model statutes. And I could tell you, I've been in those conversations. Lawyers spend a lot of time focusing on whether a comma should be there or not be there, and how it changes the entire meaning of a sentence.
Right.
Those are important conversations to have when you are writing the law. But if you're just moving the law, then it could be done more efficiently.
Gotcha. So now you have your first 106 days now, I would say. What's in store for the next 100 days and beyond?
Well, my values and objectives are the same. We are continuing to work and focus on addressing crime in New Orleans. I have good relationships with the district attorneys and the sheriffs, and I'm engaging them in asking them how my office can better serve their needs so that we can also address some of the broader crime issues around the state. And so I am committed to investing in those relationships so that we can work together and find ways that, because my office is more of a central force, how that we can support them in doing what they need to do around the state and address some of the needs that they may not be able to address simply because they're smaller communities, they're smaller forces. It may be very specialized kind of work. And so on the criminal side, I think we're going to continue to partner with those important friends and figure out how to make our people safe. On the freedom side, I'll continue to fight for the liberties and that we have. I was in the United States Supreme Court in March, and we were fighting for freedom of speech. That I think that the Bill of Rights is very, very important protection that we have, and that we all should be fighting for that, and we should be educating our kids about why it is important to fight for freedom of speech.
Gotcha. Is there any final thoughts that you want to add?
Just that I am grateful to be here and in Alexandria. I was here today for the investiture of your newest judge in Division D, Judge Lauren Lampert, and he's a good friend. I know that you are lucky to have him on the bench, and he had a lot of friends from all around the state who are here today to support him and encourage him in taking over that very important responsibility. So I am grateful that he's on the bench, and I was glad to be here with him.
Sounds good. Okay. I think that covers everything.
Yeah.